Good evening, and I'd like to call this meeting to order. I'd like to welcome everyone to the Board of County Commissioners public hearing on proposed amendments to the Hillsborough County Land Development Code. This is the first of two public hearings. The board will not be taking any final votes on these amendments tonight until a second public hearing, which is presently scheduled for September 24th at 6 p.m. Will the clerk please call the roll?
Good evening, Miller.
Here.
Hagan.
Here.
Kemp.
Here.
Merman.
Here.
Overman.
Here.
Smith.
Here.
White.
Here.
Thank you. You have a quorum.
Okay, thank you. Mr. Joe Moreda from the Development Service Department will introduce tonight's agenda. Good evening, Mr. Moreda. You're recognized.
Good evening, Commissioners. Joe Moreda, Development Services for the record. Commissioners, this is, as you said, Commissioner, this is the first of two public hearings. There's no vote that's required tonight. We'll be back on September 24th at 6 o'clock for the second and final public hearing, and at that time there'll be a vote taken. In between this hearing and the next hearing, there will also be a consistency finding that will go before the Planning Commission, and when we come back to you on September 24th, those findings will be part of the materials that are submitted to you as well. Commissioners, we have 9 amendments tonight, and I will turn it over to Israel Monsanto in a minute for the presentation on those amendments. And also, we have a host of staff that are queued up in case we need any additional questions that are responded to. Mr. Gormley's available, and Mr. Williams is also here, and we also have Tom Hisney and a few other staff that are available in case questions come up. So without any further ado, I'll go ahead and turn it back over to you to Commissioner Miller, and we also have Israel Monsanto ready to move forward with the PowerPoint presentations.
Okay, so the first one, were there any changes at all to the agenda?
No, sir, there's no changes to the agenda.
Okay, all right. So we're gonna first open up the first amendment, LDC 19-1055. Who's handling that?
Mr. Monsanto will be handling that.
Okay.
Good evening, Commissioners. This is Israel Monsanto, Development Services. I'm going to start the PowerPoint. As stated by Mr. Moreda, this is the first public hearing of 2. We have a total of 9 text amendments tonight. I will be going through each of the slides for each text amendments, and then after I'm done with the slides, we will be open for public comments. The first text amendments, Commissioners, tonight is the accessory dwelling, LDC 19-1055. The purpose of this amendment is to revise the accessory dwelling provision of the Land Development Code. With these changes, accessory dwellings will be regulated by minimum lot size, which is 7,000 square feet. Accessory dwellings will be allowed on legal non-conforming lots. They will also be permitted on front yards placed at twice the depth of the district's front yard setback, and variances to these provisions will not be allowed. And we are available if you have any questions.
Okay, this is a public hearing. I have one speaker that is signed up for this amendment, Chris Villa.
Yes, good afternoon, Commissioners. This is Chris Vella, Tampa, Florida, 33605. And yes, you're correct. I'm speaking on behalf of LDC 19-1055. I just have some just recommendations since we're talking about this. I would definitely look at reducing the 7,000 square feet down to 5,000 within the urban service boundary. And within the city limits of the county, I would just have no provision on that, just to increase ADU for affordable housing. And then the other part to this is that I would say that you should have no more than 75% living space of an attached structure or 800 square feet in the urban service area. There is a terminology for a attached structure that's called a junior ADU. So everything I'm talking about would apply for both. The other point that I have here is that there should be some flexibility when we're talking about district standards to meet affordable housing goals. So this means that there is an overlay that you should be allowed to do ADU to meet the criteria of meeting the Hillsborough County's affordable housing goals. For larger lots, but this is in section H, I would go for a limit of 2 or a combo of junior ADU or regular ADU. And then I have just one more comment here. Actually, those are it for my suggestions on this amendment. Thank you.
Thank you, sir. That's the only speaker I have for this particular item, so that closes the public hearing. And I see no questions from the commissioners on this issue. So we'll move on to the next one, which is LDC 20-0720.
It's muted. These text amendments will, the purpose is to require connections to a publicly owned and operated wastewater facility for the subdivision of a parent parcel or lot of record in the urban service area. This text change will only allow subdivision of a parent parcel or lot of record in the urban service area if the newly created lots connect to a publicly owned and operated wastewater facility. There are exceptions that will be maintained to public potable water as is permitted today by the Land Development Code. And we're available if you have any questions.
Thank you, sir. This is a public hearing. I don't have anyone signed to speak on this particular item. That closes the public hearing. Any comments by members, questions? None? Okay. That closes the public hearing on that one. We move on to LDC 20-0721.
The next text amendment is LDC 20-0721. Purpose of this text amendment is to allow public testimony by a party of record at the Board of County Commissioners land use meetings for rezoning applications without requiring that party of record to file for oral argument. It will be permissible for a party of record to provide public testimony without first having to file request for oral argument with the clerk's office. And we're available with questions.
Thank you, sir. This is a public hearing. Our first speaker is Christina Bosworth.
Thank you. My name is Christina Bosworth. As a citizen who has tried to navigate this process, I can assure you that it is currently quite complex and confusing. Establishing oneself as a party of record is relatively straightforward and really should be all one requires to provide testimony before the BOCC at land use meetings. Currently, in order to speak, in addition to being established as a party of record, a request for oral argument form must be completed and submitted to the clerk within 10 calendar days after the filing of the land use hearing officer's recommendation. The land use hearing officer has 10 business days after the hearing. So in order to ensure you don't miss the deadline for filing the request for oral argument, one must check daily for 2 weeks, longer if there's holidays, to see when the recommendation is made. This is a waste of time and can be even more confusing because one step is due in business days and the other in calendar days. The current process also creates more work and costs for county staff. The only purpose I can see for this additional requirement is to prevent citizen involvement. So I ask you to please approve this text amendment. Thank you.
Thank you. Gordon Schiff.
Mr. Chair, this is Gordon Schiff. I did not sign up for this one.
Pardon me?
Mr. Chair, this is Gordon Schiff. I did not sign up for this item. I'm on A4.
Okay, well, your name was on there. I apologize for that, sir. David Mechanic.
Yes, sir. Mr. Chairman, board members. Just to speak very briefly on this item, while I recognize the burden of having to file a request for oral argument, the idea of eliminating the process altogether really will disrupt what is an appropriate part of a quasi-judicial procedure. you will have no idea who wants to speak on any particular given item, so your consent agenda will essentially go away. Another concern that I would have with this proposal is it lends itself to persons who might speak and attempt to introduce evidence beyond the record. If you are required to file an oral argument form, then you are part of a process where you're instructed not to present evidence beyond the record. But if people are just speaking extemporaneously, it could create a lot of problems, a lot of organizational problems when you have your hearings. I don't have anything else on this particular item. Thank you.
Thank you, sir. Our next speaker is Elise Bestel, I'm sorry.
Yes, sir. Thank you. I appreciate the opportunity to speak on this amendment. First, I want to say that I think all of us that represent members of the development community understand the desire of the board to make this process easier for members of the public to navigate. However, the process was put in place to ensure that the county provides and ensures due process for all of the parties. That includes the applicant, both the public and the applicant. You may or may not be aware that participants who speak at hearings from the public under Florida law actually are not afforded the same level of due process rights as the applicant. There are two very important cases that Carolyn and the Miramar case that establish that. Under your process today, the applicant has the ability to know exactly who's going to come to speak, just like Dave said. And with that oral argument form, we at least have a general idea of what the participant intends to address, whether they have submitted documents, whether they came in at DHM, or whether they simply submit an oral argument form because they're a noticed party. You know, we have the opportunity to prepare testimony and submit a response to and a request, and this is really critical and important. We can submit a request for additional evidence if that appears to be necessary. But the proposed amendment really strips our ability to do that. Let me just give you an example. I'm presenting on behalf of a client for a rezoning. At the hearing, we have this new noticed party, someone who wasn't at the DHM, they didn't write a letter, they've never submitted evidence before, and they didn't submit for oral argument. This person comes in, they say that they're adjacent to the property. They generally talk about transportation, right? And likely they're going to give their experience related to the property. Normally, during our current process, I have the ability before the hearing to understand where that person lives in relation to the property. I have the ability to look at how the project may impact them. And if I need to, I then have the time in the process to submit a request for additional evidence to be submitted. We don't have that. With this amendment, that strips us of the ability to ask for additional evidence or to prepare. And I'm really concerned that you're causing a lot of due process issues with the way that it's written. Specifically, there's really an easy fix for this. I mean, you could keep the oral argument only for noticed parties, but eliminate it for those people that spoke at the ZHM, that submitted testimony. And I think you would accomplish what you're trying to accomplish without creating due process concerns. Because I can tell you, quite frankly, that if we change these rules and someone comes in and presents testimony that I wasn't given the opportunity to then rebut and afford in a way that is, in conjunction with Florida law, you're just going to have a bunch of lawsuits on your hand. And we know that nobody wants that. So I hope that you take a little additional time to look at the language and the definition of party of record and really think about ways that you can still achieve what you're trying to do by affording the public more opportunity, but at the same time, you ensure that the applicant is still protected with respect to their due process rights. Thank you, Mr. Chair.
Thank you. Thank you. Clerk, how many minutes are we giving each speaker?
3 minutes.
How much?
3 minutes.
Okay, thank you. Vin Marchetti.
Commissioners. Ben Marchetti, can you hear me?
Yes, sir.
Okay, thank you. 401 East Jackson Street, Suite 2100, Tampa 33602. I know Elise covered much of what I was going to say, and also Dave, but this is a fundamental issue that this Board of County Commissioners is probably not even considering. The way this language was drafted completely deviates from what I thought was the intent of what you were seeking. And the first person who spoke tonight talked about the party of record form, or the form to fill out the oral argument form. And, you know, to be clear about it, we have no objections to anyone who attended the ZHM hearing and spoke or presented evidence, documentary or testimonial, to speaking at the BOCC hearing, because we have notice of it. If you open this up, as Alicia said, the parties of record, it opens the door for anyone to speak at any issue before the BOCC on a rezoning quasi-judicial. And it's interesting because I recall the former Commissioner Platt, who we all know is a stickler for due process, but not a huge supporter of development of any kind, actually came up with the zoning hearing master process. If you approve this, you should also revoke, in my opinion, the ZHM process and revert back to having your own full-blown hearings on zonings, and plan on spending hours each month having these hearings, likely to carve out probably 2 days a month, 9 a.m. to 6 p.m. That would only be the fair way to do it. It's an interesting time that we cannot have ZHM hearings due to COVID, but this board is going to impose more procedures to follow during a virtual hearing on code amendments. How can you make major policy decisions and changes like this with limited public input? I strongly suggest that you either reject this amendment or delay it to the next cycle so that we can have a full understanding as to its impact legally and functionally. If the filing of the form is the issue, we will work with your staff to get that right. Let's not jeopardize the entire zoning process for that and waste taxpayer dollars in needless litigation. Thank you.
Thank you. Jake Kramer.
Good evening, Mr. Chairman and Commissioners. This is Jake Kramer with Stearns Weaver Miller, 401 East Jackson Street, number 2100, Tampa. Thank you for your time this evening. I won't repeat the good comments of the previous participants. I will comment on the first speaker. I do think potentially identified what can be a tricky timing issue. And I don't think that this process needs to be any more difficult than it should be. The process could be kept in a similar form as today and address the first commenter's concern. We could keep a simple process of allowing parties of record to simply email the clerk so that everyone knows when they come to the Board of County Commission for the oral argument process exactly who's going to be showing up. You know, one thing I'm not sure is being considered is I have, for example, used that process when I knew who the objector was to do some additional outreach. And I've had one case where I've resolved an issue leading up to the oral argument. So that's another reason why it's helpful to know that information up front. My other concern is that the edits, I think, have gone beyond the scope of what this board asked for in changing the words oral argument to testimony, because testimony to me implies legally that the comments before the board might be considered competent substantial evidence that this board could then rely upon rather than merely arguments for this board to consider. So I think in the concept of how this board needs to make decisions legally on zoning decisions, that it's important to call this oral argument. That's what it is. It's not testimony. So I think that that revision is beyond the scope of what the board asked for. So with that, I'd ask you to ask direct staff to work with the development community and others on draft revisions to address these concerns. Thank you.
Thank you. Kami Corbett.
Good Good evening, Commissioners. My name is Cammy Corbett. I'm with the law firm of Hill Ward Henderson. I too support your efforts to make it easier for citizens to participate in the zoning hearing process. And to be clear, when I use the term participate, I mean participating by either providing a written statement into the record or providing testimony at the hearing. However, the amendment in its current form would make it impossible for administration to develop a consent agenda for cases that are not controversial or not contested. That's because parties who receive mailed notice but do not participate in the zoning process are also considered to be parties of record. I respectfully request that you consider modifying the proposed text amendment to require a party of record who did not participate in the zoning process to file some form of written notice at least 10 days prior to the scheduled land use hearing. That would give the county and the applicant fair notice that a party of record by mailed notice only intends to address the board at the land use meeting. Thank you, and I thank you for your consideration of this request.
Thank you. And that closes the public hearing on this item. Commissioner Merman, you recognize.
Thank you, Mr. Chair. I think this is a process issue, and I was trying to recall what was the problem that we're trying to fix by doing this. And if it is to give citizens more of a voice, which I think is very important, I'm not sure that, there's several issues here. New evidence, equal rights for everybody, legal process. Are there other options? And I think at this point, I think we need to, I'd like to ask our county attorney some questions about, the quasi-judicial process. I, of course, wasn't here when Jan Platt was on the board, but obviously she did create the system for a reason and the way she did it, to be fair to both sides. So I guess I'm just kind of curious. I think we need to take some more time with this. I think we need to at least delay it for the next time that we have a hearing, so we get more information from the county attorney, because I really don't want to be tied up in lawsuits forever. I think it would not serve our public very well at all. But if we can allow our citizens to have more of a voice, a different way than doing this, I think we should definitely consider it. So I don't know what the process is here for just kind of delaying this, but after listening to all this testimony, I think there's generally some confusion, and we need to make sure, since we are quasi-judicial, that we're doing things the right way.
Well, we won't be taking a vote on it tonight. I guess we could ask staff to bring something back different if that is requested before we vote on it. But right now, we're not voting on any of these tonight.
Right. So can we? So we'd have to delay it when we vote on it next time, right? Is that correct?
Mr. Clark, are you here?
Or Ms. Lundgren?
Commissioners?
Yeah, I'm sorry, go ahead.
Certainly, it's within the board's ability at this point to direct any requested changes to the proposed text, but the board is not voting this evening on this amendment.
Okay. Well, I think that, the issue, I would like to ask you then to come back when we vote on this. I'd like to see more information about what happens if new evidence is presented, the fairness issue, the legal process. Would it open the door for people to sue us right and left? And really what the intent was when Jan Platt did this whole process going forward. So that's just my request right now. If I could make that, would be great. Thank you.
Okay, Commissioner Smith, you recognize.
Thank you. Commissioners,
This would fix a problem that we bumped into several times since I've been here. I've run into this problem myself as a citizen many times, and we've been working on it since last year. So I'm really hoping that we don't delay, that we can move forward with this. Staff has been working very hard on it. It's a small step. We've seen some really engaged citizens, like the Baum Civic Association president, and people who are involved in their community plans have come to the board as parties of record, but without having filled out this request for oral argument form. And it's been a stumbling block, an issue of an unnecessary batch of red tape, keeping citizens from speaking to their elected officials. I've heard the land use attorney's worries tonight for the first time. But I don't think that they understand this is a very, very small step to just remove one piece of the process, the red tape piece, the form. Keep in mind that everyone still has to be a party of record. So the attorneys will know whether there is opposition, who is opposed, where they live, what their objections are, because everybody will have provided testimony at the zoning hearing master hearing, either in writing or by being there. And so new evidence won't be allowed any more than it is now. It's only since you don't have to fill out this onerous form in that crazy little time window that the first citizen spoke about. We surveyed many other Florida counties and the city of Tampa, and we haven't found a single other county or city that requires this cumbersome step before people can speak to their elected officials at land use hearings. And all those other counties and cities are not being sued left and right. They're not in court. They just don't have this one little piece of red tape that just gets in the way. By the way, people fill them out in batches for each other. There's no signature required. It doesn't matter how you fill it out. All the attorneys who are on the line tonight, they fill them out in batches for their people. You don't have to fill out your own form. It doesn't matter what you say. It doesn't matter what you put on the form for the little essay question or which boxes you tick. It's just an obstacle for citizens because it looks like it's full of legalese and it's a daunting form. And the time window when you submit it, you have to wait 15 business days after the zoning hearing master, and you're a party record. You've been there. Then you have 10 calendar days to fill out this form and get it in. And then there's about 18 more calendar days to the Board of County Commission hearing. But if you miss that little window, you don't get to speak to your elected officials in Hillsborough County like you can in Pasco, Polk, Pinellas, or the city of Tampa. So, I mean, if you want to make it hard for people to speak to you, then you don't want to do this. But if no other county or city needs this form to figure out their consent agenda, by the way, we don't require it for our PRS items, our major or minor modification items, everything in the E section of our agenda. We don't require this form, and people just come and they show up, and the land use attorneys don't know who's going to come or if anybody's going to come, and we manage those items by simply asking if anyone's here to speak as a proponent or an opponent, and we don't end up in court. Development Services staff has done some research and found, there's just really 2 or 4 issues a month that might have opposition anyway. It's not that big a deal. The only reason to have this is if you want to have an extra hoop for citizens to jump through that keeps citizens from participating in the zoning hearings.
So I hope we don't delay it, and I hope we can move forward. We've been working on it since last year. Thank you.
Commissioner White, you recognize.
Thank you. Well, I agree with Commissioner Merman's sentiments. I think we have to take our time on this to get it right. And I can only imagine that COVID-19 certainly must have presented some difficulties for staff in reaching out to various stakeholders. As I've said, I want to make this process easy for citizens to navigate and not need to hire a team of professionals. But I also want to be 100% sure that we have the due process issues right. I am unapologetically supportive of protecting citizens' rights, but I also believe that parties on both sides of a land use issue have due process rights. So in an effort to get the due process issues 100% right, which is critically important, I move to continue 20-0721 to the next cycle.
Second.
Before we take a motion on that, Ms. Lugren, you there?
Yes, Commissioner.
Are we taking any motions tonight on any of these?
I believe it would be possible to continue this item. I defer to Mr. Wormley and to Mr. Clark on the LDC schedule for the cycles that are upcoming this session.
Yeah, and Mr. Chair, this is Cameron Clark. This is an advertised public hearing, so if the board wants to defer any items to a next cycle, they can do that. I would, again, I defer to Mr. Gormley as to the dates, although I'm not sure for the next round those are available yet, because I believe the next round wouldn't be until calendar year 21.
That's, Mr. Chair, if it's appropriate.
Yes, sir.
That's correct. This hearing would actually have been part of our round 2. So we don't have another round scheduled this year. We would reschedule it with the board's master calendar for next year. We were scheduled to have hearings earlier in the year, but due to COVID, the hearing schedule was pushed out to this one.
Okay. Well, with that being said, Commissioner White, I'll rule your motion in order. Would you please restate it?
Yes, it's simply to continue 20-0721 to the next cycle.
And I'll second.
Okay, we have a motion by Commissioner White, second by Commissioner Merman. Commissioner Overman to the motion.
It is to the motion because I might choose not to support the motion, but I'd like to offer a compromise. Let's say in this particular case, we were talking about the process and the party of records and the ability of someone to come to speak. It's my understanding that a party of record, and I'm paraphrasing here, is a person who speaks at a prior hearing, a person who's notified of the previous hearing by proof of mailing, and a person who submitted documentary evidence for record of a prior hearing. So I'm fine with the amendment as it stands, allowing someone to show up at the BOCC without filing a request for oral argument. But my concern is if they didn't participate in any of the prior hearings, that we don't have any way of knowing what they're going to come say, and the attorneys are going to be kind of stuck. So I want to offer a compromise, and this will be how, this is why I'm offering this, is so that it'll determine how we move forward on this motion. If anyone who spoke at the submitted documentary evidence at the zoning hearing master does not have to file for oral argument. In other words, they're already a party of record, they've submitted testimony, we know what the facts are. However, if you didn't speak or submit the documentary evidence at the zoning hearing master, you would have to file the oral argument file. That way, staff and the applicant are on notice that there's a new person who, perhaps with a different opinion as to what was put on record at the zoning hearing master's hearing. This permits staff to reach out to discuss the rules. Public testimony must be limited to that which is on record of the proceedings. In addition, by filing the request, it permits the applicant to reach out and possibly find opportunities to have a constructive conversation prior to appearing before us. If the parties show up, I'm very concerned that the county attorney would now have to have a lengthy process discussion during the actual board meeting and have the heightened duty to ensure that their testimony is kept to the record. So a possible compromise would be, to retain the filing requirement for request for oral argument only to a person who was notified of the hearing before the land use hearing officer by proof of mailing. That's an option, but if we want to continue it to work out those details, I can understand it, but we do have a complicated process, and that compromise doesn't work for the staff. I guess we have to move forward with both.
Now, you keep saying a compromise. Are you going to offer an amendment, or you just want to talk about a compromise?
Well, I wanted to run it by in discussion before we got to a motion, which I didn't know we were going to have a motion tonight. So I was going to have this conversation before we got here.
We're on the motion right now, Commissioner Overman.
All right, then I'll see how the motion falls, and then I guess we'll have the conversation.
Okay. Commissioner Kemp, you recognize.
Thank you. I was going to, ask for some clarity with the definition of party of record. And so we've got it now, apparently. Just want to check with our attorneys. That's accurate, correct. Anybody who gets notice is a party of record, whether they ever respond or anything else. Is that correct?
Yes.
If they're on the mailed notice list, yes.
Okay, so then that being clarified, I think that that would be appropriate. To me, the same thing. If they have in any way sent in an email, provided testimony at the ZHM in any way, noticed, let us know that they have some objections or concerns, that would make that they would be eligible to participate, and then it solves everybody's problem. So is that, I'm worried though that if the motion goes forward now, it's continued, and I would rather have this amendment pass now before we talk about continuing this. It just seems to me that if we passed this, that we could, perhaps Commissioner White would be interested in hearing this at our next hearing intact with that revision.
Okay. We have a motion by Commissioner White, second by Commissioner Merman. Seeing no further discussion, please call the roll.
Commissioner Miller, I got my hand up.
Okay, I don't see your hand, but go ahead. That's Commissioner Hagan?
Yes, sir.
Okay, I didn't see your hand. Go ahead.
Okay, I'm sorry. Seems to me this amendment selectively addresses due process concerns. We appear to be more concerned with due process issues of our citizens than those of the applicants. And the bottom line is we simply must have a level playing field. I agree that obstacles exist and we can improve this process, but this amendment appears to create many unintended consequences and will certainly open us up to litigation. So I fully support the motion by Commissioner White. Thank you.
Okay. Seeing no further discussion on the motion, please call the roll.
Miller,
Yes.
Hagan,
Yes.
Kemp,
No.
Merman,
Yes.
Overman,
No.
Smith,
No.
White,
Yes.
Motion carries 4-3 with Commissioners Kemp, Overman, and Smith voting no.
Okay. We move on to LDC 20-0722.
Commissioners, this text amendment is, the purpose is to establish a time limit to approve plan developments, districts, and general site plans after approval by the Board of County Commissioners. After a PD general site plan is approved by the board, a maximum 5-year period will be established to receive construction plans or plat approval. Once the 5-year period has passed, approved certified PD site plans would expire for the internal transportation network and external access points, as well as for any conditions related to those transportation network and external access point for the PD or portion of the PD. Upon expiration of the certified PD's general site plan, recertification of the PD general site plan shall require a minor modification to the PD. There is also 1-year extension that will be permitted for developers, and we are available with questions.
Thank you, sir. This is a public hearing. Mr. McElroy or Mr. Brewer, did the Belchers, would we ever get back in contact with them?
Yes, sir. They are in the system. We got them in there.
Okay, so the first speaker is he there, Herbert Belcher?
Yes, I am.
Yes, sir. We're on LDC 20-0722.
Thank you very much. I'm totally for this. I believe that we have PDs right now that are running into the 50-year mark, and they are sitting here stalled, and nothing's ever happening to the property. It's just sitting there. We need to have a plan out there to where it's subject to where the people are at today. We cannot wait 20 years and then spring something on the then occupants in that surrounding area. The area must be congruent with the people who are living there at that point in time. That's the biggest problem that we're having today, is we have such a large turnover in Florida that after 5 years, everybody is moving on. The 20-year mark is just ridiculous because we might have a different type of housing here than was initially established. And then all of a sudden they bring in another PD and it's totally different. And then everybody gets upset at it. No wonder. It's 20 years down the road or 40 years or 50 years down the road. That's ridiculous. We have to keep it in congruency. Now, we are citizens. And I hate to mention this to all those who worry about due process of the developers, but we are citizens. We have rights on our property that we deserve, that the developers cannot come in and destroy our property by degrading it. So when you're talking about these PDs, you are talking about degrading the property values of the property that is there now, not the property that will be here 20 years from now. I'm finished. Thank you.
Thank you, sir. Elise Betzel.
Yes, sir. Elise Betzel, Stearns Weaver. My biggest concern, and I know a lot of my counterparts are going to talk about the technicalities of this amendment, but I think once again, there are some unintended consequences with this, the way that this amendment is drafted. We handle a lot of very large plan development, those that take a very long time to implement, perhaps in phases of development over the course of years. And this amendment is going to disincentivize us from coming in with large master planned communities or planned communities that are going to develop out over a number of years, because we know that we will have to come back and those rights will not continue to run with the property. And what this does practically, it prevents the county from seeing all of the access points, all of the internal grid network, everything that you want to see and you want to review on these larger projects. You're not going to be able to see. You're going to see a sliver at a time. And so as you hear comments tonight, I would ask that you just think about that, the unintended consequences as folks speak. I appreciate your time tonight. Thank you, Mr. Chair.
Thank you. Gordon Schiff.
Good evening, Mr. Chair. Gordon Schiff with the law firm of Gordon J. Schiff, PA. I have some similar comments to Ms. Batzel, but I'll focus on 3 points. I think initially imposing a 5-year limitation is clearly arbitrary and presents some real concerns and may generate legal problems and challenges in the future. So I think the board should be aware of that going in. And I suggest also that you really should allow for the possibility of the BOCC approving a greater period of time for a project. There's opportunities to do phased projects, multi-phase commercial projects that, again, unintended consequences here are going to be, this is an incredible disincentive to those highly technical planned projects, and I think it's probably not a consequence that would be very good for the county. It also may affect land values, which is something really to consider. The second point is that, and this is not an uncommon practice, and there needs to be tolling considered. Tolling is a pretty standard practice in the state of Florida with regard to emergency orders, with regard to building permits and development orders, but it's not clear that the county has considered the possibility of tolling. When you set a deadline on something, tolling should also be considered. And then the third area just to mention is that on the existing PD subsection, it appears really overbroad, and it could lead to some real unjust and unintended consequences, and that any change could potentially take rights away from a project seems very overbroad to me, and again raises some real legal problems and potential legal challenges in the future. So I think I want to bring that to the Commission's attention tonight, and I'm sure others will speak on similar issues, but appreciate your time, Mr. Chair and Commissioners, and appreciate your consideration.
Thank you. David Mechanic.
Yes, Mr. Chairman, board members, David Mechanic. I'll try not to repeat what the others have said, but the idea that a project, and again, we're talking about larger multi-phase type projects that might by necessity take many, many years to build, and it could be 20 years, and I'll give you an example in a minute, but it would present a terrible burden on a project to not know what regulations it was facing for its second, third, or fourth phases. I think it would also create significant problems in terms of obtaining financing for such a project. I did some research today, and I hadn't really thought about this when I presented these arguments to the staff, but I believe this provision is actually in contravention of Florida statute 163.3175. That subsection says, nothing in this act shall limit or modify the rights of any person to complete any development which has been issued a final development order and development has commenced and is continuing in good faith. The standard under the statute would simply require that you commence the development and proceed in good faith. And let me give you an example. The city of Tampa has a similar termination provision, but it allows you to continue without further review if you have substantially commenced your development within the 5-year period. In the city, I've represented International Plaza Mall, and we have added to that mall significant projects over the last 25 years. And under the provision that's currently being considered by the board, I would have to have gone to city council 5 or 6 times to re-up to get a new approval for the development. it's a perfectly logical and natural thing that a development of that magnitude would take that number of years, and you should not expose a development to have it to come back and comply with a new set of regulations every 5 years. I would very respectfully suggest that we be given an opportunity to work with the staff and work out some language that would be in compliance with Chapter 163 and address our concerns. I would just like to say, Michael Brooks has submitted some language. I think
Mr. Mechanic, your time is up. Mr. Mechanic, your time is up. Thank you very much. Vin Marchetti.
Yes, Commissioners, thank you again. 401 East Jackson Street, Tampa, 33602. You know, David brought up some great points. He's worked on a lot of mixed-use projects in the past. He's developed a lot of properties with his clients that are significant, and frankly, so have we at Stearns Weaver. So I'm going to just give you a couple of case examples, and I'll tell you right now that if this were in play, these projects would not have been built, or will not be built. Coca-Cola is one with corporate headquarters and distribution manufacturing, and that's a phased project. It's not, they can't build a project in one phase. It's impossible. And so, but they will be putting all the infrastructure in. They'll be getting all the road network complete. And so, again, for financing purposes, and David mentioned this, it's going to be impossible for anybody to get financing with a 5-year window. And also back in the 90s, I just mentioned this, we had a similar situation regarding comprehensive plan when it was changed. And actually, when I worked for the county, I developed the vested rights ordinance, which allowed people to go through a vested rights process, like David said, when you have investment-backed expectations, when they spent money in reliance upon the entitlements and put infrastructure in and did other things. And so we created this ordinance, which is still, I believe in this land development code, but you would have to basically, in my opinion, resurrect that, if you did anything like this, resurrect that vested rights ordinance and allow people the opportunity to continue projects without having to go through another zoning or hearing, or, you know, the hearing would be a vested rights hearing. And another example is the University Mall project, which we're working on up there in North Tampa. That's a huge project. It's going to take probably, speculation, 10 to 15 years to develop out, maybe longer. And again, the owner there, RD Management, they're doing it in a phased basis. And the way this is written, it's very broad. I agree with David and Elise and others. It's very broad, and we need time to work on the language. And I think if you can give us some time, we can work together with staff and get this done. Thank you.
Thank you. Jake Kramer.
Thank you, Mr. Chairman. Jake Kramer again with Stearns Weaver Miller. Mr. Chairman and board members, this is a significant policy change that really we shouldn't be considering during the middle of a pandemic. There's been very limited time for public input on what I believe to be probably the most fundamental change to this county's land development system that's been proposed in a long time. You've extended land use moratoria primarily to get more public input, and I would ask that you consider doing that here so we can take time to work with your staff and get this one right. I've appeared in a number of jurisdictions around the state, and I can tell you I've never seen such an onerous PD expiration provision anywhere in Florida. As written, if your PD expires, you can't do anything at all with your property without coming before this board. And my colleagues have talked about the large projects. Let's think about the little guy, the little guy who needs a tweak to their zoning, and they spend $10,000 to file a PD, and then we have another recession, and they can't move forward immediately because they were hit hard by that recession. And then they've got to spend thousands more dollars just to come back to this board and beg for the right to do anything at all with their property. That just strikes me as fundamentally unfair. This amendment promotes uncertainty, which is the worst possible thing you can inject into the development process, especially in the middle of a pandemic. And I would question, with a lot of projects out there, if the PD were to expire, I think that'll cause a cascade effect on some of these projects where you could see defaults under contracts and loans for projects that are relying upon zoning being in place. I agree with Mr. Marchetti's suggestion that if you do move forward with that, to consider looking at the vested rights process so that this board is not put in the position of a project that's in the middle of being built, being stopped right in the middle of that, and then coming back before this board for a political decision of whether that project ought to be able to consider it. Appreciate your time tonight, and thank you.
Thank you. Elizabeth Belcher?
Yes. As other people have said, it is people on property have rights also, and it's about time the playing field was leveled. There was an attorney. First of all, let me put this on record. I signed up for this hearing. I've been denied making comments on the previous LDC meeting hearing amendments, and like I said, I just wanted to put this on record that I was denied that right because I signed up and I could not get on. I was not recognized. Going back to this one, people who own property have rights also. One prior attorney said that the developers have more rights than the owners of property present. That is ridiculous. Why should they have more rights than I? And things change. I mean, 5 years down the road, you have new regulations, new code enforcement, new things happen. And these subdivisions get grandfathered in under the old rules and regulations that are damaging the property values of those out here, the environment, et cetera, et cetera. It's about time that the citizens of Hillsborough County have a right to have a say and have a certain on what's going to be done. You can't all of a sudden we have an example right out here that this thing was approved like 5-10 years ago, and all of a sudden it's jumping up. People can't handle it, and people are outraged, and they don't understand what's happening. That's it.
Kami Corbett.
Good evening, Commissioners. Kami Corbett with the law firm of Hill, Ward, Henderson. I too share the concerns expressed by my colleagues about this amendment, and I think they've all advanced very good arguments this evening about why this language needs more work, regardless of whether it's continued or it comes back before you. And specifically, I think there are 4 aspects of the amendment that still need to be addressed. First, the applicability of this amendment to pending applications which have been delayed due to COVID-19. 2, situations where substantial construction or infrastructure of the entitlements have occurred. 3, the types of modifications that might trigger the application of this regulation. And 4, equitable considerations for situations where the application of this regulation might be unfair or unreasonable. I think what Mr. Mechanic started to say at the end of his comments is that the land use attorneys who are commenting this evening have been working together and trying to coordinate with your staff and your county attorney's office to address these issues. A draft of the language has been submitted to them for their consideration, and I respectfully request that you ask staff to continue to work with all of us on this amendment to address these issues. Thank you.
Thank you. Did Michael Brooks ever come on? Staff?
No, sir.
Okay, thank you. That closes the public hearing on this item. Are there any questions from the members? Any comments from the members?
Commissioner Miller, I have my hand up.
I do too.
Okay, staff, the hand signal is not working again tonight. I don't see hands on here. So you're gonna have to get my attention because it's not working. Pardon me, hold on. Commissioner White, you recognized.
Thank you. Much like the last item, I'm supportive of making amendments to the LDC that recognize that things change in communities over time. In fact, it was me that pushed several years ago for an idea of sunsetting certain site access provisions within PDs after a period of time. But at the same time, I'm a staunch supporter of private property rights, and I want to be 100% sure that we get the property rights issues correct. I know there are concerns out there about the private property rights issues. So in an effort to give staff plenty of time to address them, I move that we continue 20-0722 to the next cycle.
I'll second.
There's a motion by Commissioner White, second by Commissioner Merman. Commissioner Merman, I see your hand. Are you recognized?
Thank you very much, Mr. Chair. I think this is, listen.
To the motion.
Okay, I have been in favor of a time limit since I've been on this board, but never 5 years. And when I saw 5 years, I said, there's just no way that could happen because, as you know, in the state of Florida, we go through a recession like every 9 years. That's the cycle that's always, anticipated. So this really needs some more work. And the 5 years just isn't going to work on these big projects like the mall, several others that are out there. So that's why I'm supporting this. It's not that we don't need some kind of a limit, but I just think this needs some more work so that we all understand completely what this is going to mean, especially for the economy here in Hillsborough County. Thank you.
Okay, I think I saw Commissioner Smith, your hand is up. It's working. That's at least that part.
Yes, I'm just going to say I can't support the motion because we really need this. There are example after example I could talk about this, of PDs that have been on the books for 20 years and nothing happened to them until they finally came up, and then they've got a plan that we would never approve today because it wouldn't work with our transportation system as it is today. And yet they can go ahead and do it that way rather than come back and work out something with us, with our staff that really does work with our current system. So, but without that, it's just easier for them to go ahead and do the easier path to do what was an old-fashioned plan they might have gotten from several different property owners ago. That property may have changed hands, and now they just go, well, I'm just going to do what's on the ground here, what the zoning says, because I don't want to have to take it back through. But we're missing that opportunity to make it work. So I'm really disappointed to see this being delayed tonight.
Commissioner Smith, let me ask you a question. I kind of got confused what you said. You don't want it to go beyond 5 years, but I thought you said you also want to go back and allow staff to work on it.
No,
is that what you said?
No, I'm happy with this, so I won't be supporting the delay. I'm saying, sorry, that the situation we have now needs to be fixed so that we can modernize PDs that have been languishing on the books before they get built and make sure they work with our transportation system.
Okay. All right. Was anyone else wanted to speak? Anyone else wanted to speak?
Yes, please.
Okay. Hand signal is not working. Commissioner Overman, you recognize.
Thank you very much. To the motion, the only reason I would support a continuance at this point is because I think there are some issues that do need to be addressed. I too am looking forward to having a more certain possibility of implementing not only the adjustments in our comprehensive plan going forward, but also to assure that when we make those changes, which we do periodically, and we do address them usually within a 5 or 6 or 7 year period, that the site plans that have been approved, the new site plans, because this addresses new applications. This doesn't go back and fix the massive amount of problems for projects that have been on the books or been zoned for the last 20 years. This addresses new applications, new PD general site plans that may not move at all or may be in the process of moving, that every 5 years they have to put a stick in the ground and say, hi, yeah, we're moving forward. And that's what this, if I understand it correctly, that's what this is asking. It's not changing the whole plan. It's making sure that a plan that is going into a community meets the needs of the people that will not only live there, but the people that do live there, and also serves our growth plan. We've heard we're growing leaps and bounds. And to not be able to go back and say we have to implement changes is the way the world works. Now, granted, yes, economic cycles run every 2 to 5 years or so. They're a lot shorter than they used to be. And so there is an opportunity to address changes and allow developers and investors to move forward. But to continue the process of the speculation that occurs that doesn't actually manifest, until 10 or 15 years down the road is not fair to property owners in the neighborhood. So while I'm willing to ask for a continuance, it is in an effort to address the concerns that were brought forward today for the new projects that would fall under these rules. But I would not really want to move far away from what this original amendment stated, which is to address the time limit for new applications, to address PDs and the plans to keep them current enough to deal with our growth plans and our comprehensive plan. I'll stop there.
Okay, Commissioner Kemp, you recognize.
Thank you. I'm just going to ask again, our attorneys drafted this. So did you see this in other jurisdictions? Is this I can't imagine that you put this forward without telling us that it wouldn't, involve all kinds of lawsuits or all this other, or, developments. I would imagine the development that some of the speakers talked about, an ongoing continuous development, would meet, some of the standards that are in this now. Can you just address some of these legal issues? And after you do that, I'd like to ask another question.
Ms. Lundgren, you recognize.
Commissioners, we worked with staff on this amendment. I've reviewed it. I'm comfortable with this amendment from a legal standpoint. I'm aware that there are other jurisdictions that have limitations on PD site plans. The city of Tampa, I believe, is one. Staff may have more information about other jurisdictions that have been evaluated.
So there's flexibility in this for the kinds of concerns that were brought forward. And if there's any idea that we need to further make some based on tonight, something could be brought back to us for the next hearing. So it doesn't have to jump a whole cycle again, correct?
Certainly the board is able to make recommendations tonight and have amendments made in preparation for the final public hearing.
Well, I guess we could also do this and at the next cycle, if we need to make any adjustments based on anything, because you said it's legally sound and feel that it's defensible, that it's being used in other places. So any issues with this could be also in the next cycle. Modifications could be made if we need to do that. I'm frustrated too that I hear that, oh, we've wanted to do this forever, but then people have had 10 years to bring this up. It's never been brought up. So I'm going to be supporting it moving forward. And I think if there's some issues like the ones that suddenly have come up, that those can be addressed in the next cycle.
Commissioner Hagan, you recognize.
Thank you, Mr. Chair. Along Commissioner Kemp's remarks, I'm not going to make a motion asking staff to research what other counties have done, because I tried that a couple days ago and the board wasn't interested in what other counties are doing. However, I would like to know from Ms. Lundgren, what are the other time limits that you've found out in your research?
Commissioner, I've not done an extensive amount of research on this. I have looked at the city of Tampa's 5-year limitation on their PD site plans. I believe, I'm not sure if staff has researched other jurisdictions, but I know that they do. There are probably other jurisdictions that have such a limitation.
Right.
I am aware of the city of Tampa.
Well, again, I think it would be prudent to know what other jurisdictions are doing. Again, I tried that a couple days ago, and the board's not interested in knowing what other counties are doing with respect to land use issues. So I'm not going to ask for a motion, but I think that would be prudent.
Commissioner White, did you want to say something else? I see your hand is up.
Yes, sir. Briefly, I just want to state for the record that for both 20-0721 and 20-0722, the one we're talking about now, my gripe is not with the county attorney's office. I take their word at face value that these are legally sufficient. I just want to make sure that this board does not enact policy that has unintended consequences. At least one speaker tonight used that phrase, unintended consequences. So I don't think moving this to the next cycle hurts. Just to take our time, make sure that we fully engage all stakeholders and get this 100% right so that we don't enact policy that has unintended consequences. So my goal would be not so much for a detailed legal analysis, but rather for county administrator staff to reach out to various stakeholders to make sure that they've heard all the concerns out there.
Okay, we have a motion by Commissioner White, second by Commissioner Merman. Please call the roll.
Miller?
Yes.
Hagan?
Yes.
Kemp?
No.
Merman?
Yes.
Overman?
Yes.
Smith?
No.
White?
Yes.
Motion carries 5-2 with Commissioners Kemp and Smith voting no.
Okay. LDC 20-0723.
Mr. Chairman, the next text amendment is 20-0723. The purpose of this text amendment is to require additional information related to transportation in plan development site plans. The information will be required in general plan development site plans at the time of application submittal for rezoning for PDs, major modifications, and minor modifications. Identification of cross-access and connectivity opportunities to surrounding sites and parcels for proposed plan development zoning districts in the context of the overall roadway network in the area, and also alternative design considerations to these requirements will be required to submit a PD variation request in accordance to the Land Development Code, section 50306C6, which are the plan development variations. And we are available with questions.
Thank you very much. This is a public hearing. We have two speakers signed up to speak on this. Herbert Belcher.
Yes. I'm totally for this. I believe that we need to have a transportation system that is consistent across the entire county. We have currently just all kinds of makeshift roading and everything that developers have come in and put in and then just left willy-nilly down the road, and that's it. They're deteriorating. The subdivision roads are just atrocious in many of the areas that are not more than 5 or 6 years old. So that is the biggest issue that we have out in the county. This is in a rural service area. So I would suggest that somehow this transportation plan deals with emergency equipment such as fire trucks, police, etc., being able to get to places very expeditiously. Thank you.
Thank you. Elizabeth Belcher?
Hello? Yes.
Yes.
This amendment, I'm not questioning what you're trying to accomplish. It would be helpful if you would put out
Ms. Belcher, you're breaking up.
Of what happens under the, and if these are changed, what would happen under the new existing rule? Because I'm not really funny. I don't understand what you're trying to accomplish. Thank you.
Okay, that closes the public hearing. Commissioner Overman, you recognize.
I've learned I need to get my hand up faster.
No, it's working now. I see your hand.
All right, great, thank you. The purpose of this amendment is to require additional information as it relates to transportation in the planned development site. I like these changes, and I'm happy to see that we're finally moving forward to provide multiple direct connections in our local street systems to parks, schools, and shoppings without requiring the use of arterial streets. This will transform our county into one that is connected, fully connected, and easier to get around. It will provide our residents with the opportunity to get to where they need to go without adding congestion onto our arterial roads. And I look forward to working with staff on moving this forward. So if you need a motion to move it forward,
No, ma'am, we're not voting on that tonight. That comes back in September.
Okay, that's all.
Okay. All right. Okay, you move on to LDC 20-0724.
Mr. Chairman, the purpose of this text amendment is to expand the number of roadways from Class 5 to 6 on which vehicular and/or pedestrian cross-access may be required. Expansion of the application of the cross-access requirements to Class 6 roadways such that cross-access is required for projects on all collectors and arterial roadways when specified conditions are met. We are available if you have questions.
Okay, this is a public hearing. Herbert Belcher.
Yes, I'd like to agree with this 100%. Again, just as the other speakers mentioned, I don't know the difference between a Class 5 and a Class 6 roadway. It would be nice to know an example of one or the other so that we have a better opportunity of understanding more out in the local areas. But technically it does sound better. Thank you.
Elizabeth Belcher.
Again, like I said, I don't really understand what these amendments are accomplishing. If it's coordinating what is planned with what is actually proposed, that would be a nice thing. If you could just give us an example, hard examples of Plan A would do this, Plan B would do that, Plan C would do that, it would be very helpful for the public. Thank you.
Did Chris Villa ever come back on?
No, sir. He's out.
Okay. All right. That closes the public hearing. And I see no hands to discuss this particular item. So we move on to LDC 20-0842.
Mr. Chairman, this text amendment, the purpose is to clarify additional alternative for emergency access connections within all planned development without requiring a rezoning modification. Addition of emergency access ways for planned development zone projects which are non-residential within site development process without requiring an amendment to the PD plan. And this will provide same design standards for emergency access ways found today within the subdivision portion of the land development code. Are available if you have any questions.
Thank you, sir. This is a public hearing. We have two people who's signed to speak on this issue. Herbert Belcher.
Yes, thank you. I am totally for this. We need to have more emergency access, especially on the subdivision roadways. Many of our subdivisions are clogged. People park in the roadways, blocking traffic, where emergency vehicles cannot get through. I've seen emergency vehicles go up people's lawns to avoid traffic. So I understand this concept. We need to make sure that when developers put in roads inside the subdivision, that those roads are wide enough to where they can accept cars parked on the road and allow these large fire trucks to pass by. That is imperative. Today, they're responding to with large fire trucks just for EMTs because that's who they have on board the truck. So we need to make sure that this is done, and it's very important. Thank you.
Thank you. Elizabeth Belcher.
Yes. The attorney's previous statements are talking about unintended consequences. And my question regarding this one, unintended consequence, is the fact that if all you go in and change the PD plan to allow another access point, will that can that be a loophole to the developers to revamp the whole plan development without going in and getting zoning approval? My thing is require 2 access points for every development from now on in, and that should take care of the problem. Thank you.
Thank you. That closes the public hearing. Seeing no hands to speak to this particular item, we move on to LDC 20-05. I'm sorry, LDC 20-0855.
Mr. Chairman, the purpose of this text amendment is to allow backyard chickens on residentially zoned lots. This will permit the keeping of chickens on residentially zoned lots developed with single-family and two-family homes. Maximum of 5 hens will be allowed. Roosters will be prohibited. Chickens must be kept in enclosed coops at all times in the rear yard. There are restrictions on height and size of the coop. On-site slaughtering and egg sales will be prohibited, and their variances to these regulations will not be allowed with this text amendment. And we are available if you have any questions.
Okay, thank you. This is a public hearing. Herbert Belcher.
Yes, thank you very much. I have major problems with this because I live in a deed restricted community, and I understand through previous meetings with the staff that this is not going to affect us. But I see nothing in writing on that, and I have looked for it hither and yon and cannot find anything that says that it's not going to violate our code, our deed restrictions. That's my major issue. Again, we live out in the rural area, but we live in a deed restricted community, and we don't want this. So thank you very much.
Did Karen Mackles call in?
No, sir, she did not.
What about Martha Peterson? Did Martha Peterson call in?
No, sir.
Okay. Next speaker is Shelley Carty.
Hi, thank you so much for your time, Commissioner and board members. I would highly recommend that you approve for backyard chickens. I'm sure you're very, very aware of the situation going today. I mean, even sending our kids back to school is up for the debate. having backyard chickens is allowed in the city of Tampa, but because I live 5 miles outside of the city, I'm not allowed to have backyard chickens on my own private property. This is my right. I understand the concerns that were raised over the last board meeting, such as noise. I live very, very close to 301 and 75. I can tell you the noise chickens make is less than what I hear from traffic from a road. As far as being deed restricted, that would be up to the individual communities. I do not understand why one deed restricted property would hinder other law-abiding, tax-paying residents to have this ability. I would be more than happy to meet with you guys and answer any kind of questions. I mean, apart from the educational, the health benefits are just amazing. But again, I thank you so much for this consideration. Thank you for your time.
Thank you. This closes the public hearing. I don't see anyone speaking on this. I personally think this is discriminatory because you can't have roosters. I think that is discriminating against roosters. That's all I got to say. Okay, LDC 20-0856.
Mr. Chairman, the purpose of this text amendment is to add a provision to toll the calculation of the 6 months time frame limit for an application to be heard at a public hearing in the event the public hearing is canceled by the county during that 6 month period. This would allow to pause the calculation of the 6 month period when the public hearing is canceled due to county closures during emergency events. Once a public hearing is rescheduled, the calculation of time for the 6 month deadline for an application would resume at the next public hearing. And we are available if you have questions.
You done, sir? I could barely hear you. Done?
Yes, sir.
Okay. All right. This is a public hearing. Herbert Belcher. Herbert Belcher. Elizabeth Belcher.
I just want to clarify a couple of things. One, if the county cancels the meeting, does that reset the 6 month calendar? And two, when you go down to a zoning master hearing and the applicant comes in and cancels, there should also be a limit on how many times the applicant can cancel the meeting. Thank you.
Okay. Anyone that closed the public hearing? Anyone wishing to speak on this last item? And I don't see anyone wishing to speak. I think that's all the work we have to do tonight. Is there anything further we need to come before us, Mr. Gormley or Mr. Moreda or Ms. Lundgren?
That concludes our agenda.
Pardon me?
We'll see. So that concludes the agenda. We'll see September 24th, and we'll also be bringing back a consistency finding from the Planning Commission at that point.
Very good. Very good. If there's no other business to come before us tonight, we stand adjourned. You know, have a safe week and weekend.
Thank you.
Bye-bye. Bye.